We are recording and we are live streamed now. And we'll just give it another couple minutes here, Kathleen, on your signal then to go ahead and get started. Just taking a look here. Hi, Tim. Nice to see you here. Dana, Joe, and Dawn. Getting a good group here.
Everybody.
Hi, Justin.
Good morning, this is Dana Miller, Yakima Nation.
Good morning, Dana. Glad you are with us.
Yep, thank you.
And work group members, as we start here, we certainly encourage you to turn on your video, and you all are experts at keeping yourselves muted unless you're speaking, so thank you for that. And for those who may be joining us, and I'm not certain yet about any folks that we may have from the public, but if we do have any observers on, if you could please join using the live stream, and we have the link to the live stream on the welcome screen. Lauren Dennis can also help you with that if you need a little advice before you hop over to live stream, but we would appreciate that. Okay, hello, Nicholas. So it looks like Katie's about to join in. Lorna is here. Good morning, Lorna. Just seeing who I haven't said good morning to. I think we have a pretty good group. What are you thinking, Kathleen? Shall we go ahead and get started?
Let's do that.
Okay, as will be of surprise to literally no one, we have a very busy day, busy morning, and busy agenda. So thank you. And again, really appreciate seeing everybody here. Let's go ahead then. Just a quick mention again about public participation. If you are a observer and you're in the meeting, we'd sure appreciate it if you would hop over to our live stream. Just helps us to keep the room here, the visuals, just a little less congested. So thank you ahead for that. We will have a public opportunity comment tomorrow at around 11:45, and we'll say more about that tomorrow. But please do feel free to join us today, to join us tomorrow, and to make a public comment at that time. We do always invite written comments. You're welcome to send those to us. That address for you to send those is on the screen right now. So please feel free to use that and hop over to our live stream, public observers. And again, we're very glad that you are here. So welcome and agenda review. Again, very glad you're here. Reminder, the meeting is live streamed and recorded. I think we're all very familiar with that. We're also, I think, all familiar with the Zoom controls. So we're actually not going to walk through those, but please do shoot us a message in the chat if you have any questions or if you have any technical difficulties. Lauren is here to help you. So I'm Susan Heyman with Ross Strategic, facilitating today. Rob will be with us tomorrow. And Lauren and Michaela are with me from Ross today, and they're going to be making sure the technology and the documentation, all that important background and functions are occurring. So thank you for that, Lauren and Michaela. So we are at Ross very grateful to continue to have the opportunity to be working with all of you. And we're going to do our best to support a really creative, productive discussion today at the meeting, and invite you to be really creative as you think about ways that the state might be able to do some expediting of permitting processes for transmission infrastructure, new and upgraded transmission structure infrastructure. So anything we can do to help with that, please let us know. If you have any concerns during the meeting, don't hesitate to message one of us on the team, and we will do our best to try to fix that up. Before we go any further, though, Kathleen, would love to turn this over to you for some opening remarks as the chair and FSEC.
Thank you. Good morning, everybody. It's been a couple of months, and a busy couple of months in the legislative process. As we mentioned before, there are some clean energy bills going through that legislative process, and so we will have an update after the session concludes in early March. But I really want to thank you for your participation in this work group, the Transmission Corridor work group. And I would also like to say that we've learned a lot over the past 3 meetings. We're in meeting number 4, and today we will have before us, or during this 2-day meeting, you have the digging in, if you will, to the siting and how that can be improved, along with making sure we maintain our environmental review principles, our cultural sites principles of making sure that we are in contact and working closely with the tribal nations in our state. And you also have a document that we've been sent that is putting together our findings, challenges, and principles related to siting new or enhanced transmission infrastructure. So we have a lot of work that is beginning to build, and we look forward to our conversations, new learning the next couple of days to move this process one step forward. So welcome and thank you.
Thanks, Kathleen. Appreciate that. And Joe, you normally are invited to make comments here, and you'd be welcome to do that. I know you're also going to provide us some framing in a minute. So did you have anything to add right now?
Not right now. Thanks everyone again for attending, and I will I'll say some things to set some context in a bit.
Okay, fantastic. Thank you. All right, let's move ahead then. And Kathleen really touched on the meeting objectives for today. Let me hop back here. These are on your agenda, so I'm not going to read them or try to repeat what Kathleen just did. The main thing I want to do, though, is just to emphasize again that this meeting really enables the discussion to begin about recommendations to expedite and the review and permitting of the new or upgraded transmission corridors and equipment without compromising those important environmental, cultural, and other resources that Kathleen mentioned. So that is really where we are headed today. So our agenda, we have an agenda for today and also for tomorrow. Again, won't read that to you, but just want to mention that after this brief introduction, we'll go into our usual round robin, and I'll touch on those of you that are members here to see if you have any insights or any comments that you want to add. We have some time to do that. And then we'll hop into Joe's overview of the transmission line context. And we think that will really help set the picture for then what we're doing the rest of this morning and tomorrow, which is thinking about and talking about people's experiences and their learning about federal transmission line siting and permitting processes, state, the nexus of those, and then tomorrow we'll be hearing about the perspectives from the utilities on what it is to be an applicant and how that feels. So that's really what our framing is today. We have presentations, we have some discussion time. We also are going to be using our mural board to collect your insights and observations during the presentations, and I think you're, again, probably very accustomed to that. Lauren will drop a link to our mural when we are ready to get to that point, and then we'll remind you again about how to access the board. So we'll have presentations, we'll be collecting information, we'll have opportunities for some Q&A, and tomorrow is really where most of the discussion will occur. So tomorrow, again, that's what it looks like. And that 1020 section tomorrow is where we're really going to try to dive into the emerging principles that we've heard from today and also from that earlier presentation that will occur tomorrow. So the Ross team will be doing some work in between today and tomorrow to help frame that conversation up. All right, so I think with that, I'm going to go ahead and move into the round robin. What I'd like to do is, I think you all know how to access your participant panel. It's usually on the bottom of your screen there. If you want to open that up, I thought what I'd go is just from the bottom and go up and just touch on folks that are dialed in here who are actually part of the work group. You certainly don't have to make a comment, but if you do have something to say, we'd love to hear it. So if it is okay, Will, may we start with you?
Sure. I don't really have anything pressing at the moment, but just glad to be here.
All right. Thanks, Will. Let's see, Tim, I'm going to hop over you as a speaker. Stu, how about you?
Sorry. Yes, I have trouble unmuting. Yeah, Stu Anderson, FSEC, thanks everyone for being here. Really excited about this. Particularly this idea of, FSEC's been doing in the last few years a lot of streamlining work, and I know, and it's there's always a kind of panic that people go into. Oh no, we're cutting corners. We're not going to we're not going to be as careful about things. And we've really been, like, for example, we helped streamline the solar application, and what that involved was we didn't reduce any standards. There were some things in our law that didn't apply to solar. They said, well, you don't have to address those because they were just irrelevant. So getting rid of irrelevant things. We also set up the application. We found out what really harmed things was when people found out at the last minute that there was a year-long study they had to do. So to streamline things, we just focused at the beginning to figure out what were all the big pieces that had to be looked at. So those could get looked at in a timely manner, but start right away and things like that. So really emphasizing that's what this is all about. It's not about cutting corners or reducing anything. It really is about finding ways to do the what needs to get done in a better fashion. So thanks.
Great. Thank you, Stu. Stephen, how about you? That would be Stephen Moses, that is.
Yep. Sorry, guys. Having the same problem trying to unmute. I think from my perspective, it's primarily cultural resources, which is what I've been involved in for 17 years. And I always shiver whenever I hear anyone referring to streamlining any sort of process, because one of the first things to always go is cultural resources, is archaeological reviews. It's the state of Washington on paper considers it a high priority, but in practice, it isn't. Really, from any agency for any city, it's not a priority. And so, with what this group is talking about, transmission lines generally have a very high probability of disturbing not just archaeological sites, but culturally sensitive sites. And so I just want to make sure that at the very minimum, cultural resources are treated like all the other resources and not shoved below everything else. And with that being said, I'm hopeful with some of the conversations and presentations that we've had that I think cultural resources will definitely be more respected at the end of this process when it comes to what we're trying to accomplish. And hopefully that, can filter down to other agencies, other jurisdictions, and other consultants and contractors.
Very good. Thank you, Stephen. Appreciate your comments. Steve Chung.
Hey, good morning. Appreciate being part of the ongoing collaborative discussion. What interests me here, we're kind of at a point where kind of excites DOD, and that is on the portions on ways to expedite review and permitting. We've had lessons learned throughout the West Coast and several other parts of the country working with both state agencies and some of the regulatory agencies. So as we evolve in this discussion today and probably subsequent discussions, we'd be more than happy to share some lessons learned on how some of the agencies and states were able to expedite certain aspects of their reviews, whether it be for transmission or for project-specific level initiatives. So glad to be part of this discussion. Thank you for having us. Over.
Oh, very good. Thank you, Steve. I am also seeing some names here on the list that are not necessarily names that I recognize as work group members. So if you are a work group member and you have kind of an abbreviated name, or if you could go ahead and rename yourself so that we know for sure, and then I will hop back to you if I pass you by. I'm also going to focus first on the primary members, and then we'll go to alternates as we have room. So if you feel that you've been skipped over, it's not because you're not important. So that having been said, I'm going to go to Joel Nightingale with UTC.
Thanks. Yeah, good morning. I don't know if I have a whole lot to comment on with the notes for the meeting, but I appreciate Stu's remarks about what expediting means. Not cutting corners, but just finding ways to make the process more efficient. Yeah, I think that's all I have for now.
All right, thank you, Joe. Let's go to Nicholas Garcia, please.
So thank you, everyone. Nicholas Garcia here on behalf of WPUTA. I'm just going to mention how urgent this effort is. I gave a presentation about how the system is reaching its peak during various periods of time. And I recently were talking to a transportation manager for one of the major utilities in Washington State, and he let me know that an organization called the Grid Reliability Coordinator that's run out of CAISO that operates up here in the Pacific Northwest has recently imposed new requirements. And effectively it will, as what he asserts is that it will lower the amount of capacity that's available on our transmission system. And that will further create problems for us down the road if we don't figure out a way to expand our transmission corridors. So this is really, really important work, and I'm hopeful that we can, come to some agreements as to how to proceed. So thank you.
Thank you, Nicholas. Appreciate your comments. Mariel with Front and Centered, would you like to share any observations or make any comments?
Hello, good morning, everyone. Yes, I see Bruno. Just that I kind of appreciate all of the contributions that everyone has made, and the varied perspectives and considerations on just the different communities and stakeholders who the impacts need to be considered. It's not solely a question of transmitting energy, period. And this question has been just given a lot of dimension in the discussions that preceded, and I think what's coming up. I also just want to emphasize that change can be great, and I think that needs to be what we all keep in mind moving forward, that it's not just problem solving, it's looking and seeing an opportunity here, especially for opportunities for how the process can be enriched, not just streamlined, opportunities for growing knowledge and connections and engagement. I just think we're in a moment, and it would be unfortunate if we took a moment and we took all of these varied perspectives and we ended up with something that didn't really look any different in terms of how communities are considered and brought in terms of tribal interests and cultural considerations, in terms of innovation, in terms of the environmental impacts, which are significant, and thinking about just what could be. And I remain positive about coming out with something that is broadly considered progress and beneficial.
Thank you, Mariel. Appreciate your comments. Lorna with PSC, let's hop over to you.
Sure. Hi. I would just echo what everyone else has said. I agree with all those comments. I think with regard to cutting corners, we've been around in this state forever. And I would just say that when you cut a corner, it catches up with you. And I just think because he pointed out cultural resources, I know, gosh, it was probably 20 years ago. I mean, we actually brought in a cultural resource scientist full-time to get a full-time person in that position. And the things that we've caught because we have a full-time person, and I'm not going to sit here and say we've caught everything, but just investing up front in the right resources and making sure you're not cutting corners even accidentally does pay off dividends. So I would say that what I really hope out of this is, again, echoing what other people have said, I think that, you know, making sure there aren't duplicative processes. I think, you know, I hate to keep using the word streamlining, but it's apropos. I also think more certain timelines for decisions is something as a utility that with this whole CETA and the carbon transformation that we want to make, you know, we do energy resource planning 20 years in advance, and we think that we plan transmission lines way in advance. You know, everyone knows what's going to be needed on kind of that 20-year, 10-year timeframe. But we're finding that 10 years is not enough time to permit even the simplest transmission line that's an upgrade in an existing corridor. It's just not, that's not even enough time. And the tension we have is that we plan so far in advance. And if we have to add more time, like start counting needing 12 or 15 years to plan transmission lines, we butt up against things where people will say, well, you don't need it yet. Well, yeah, we don't need it yet, but we're going to need it in 12 years, and we know the process is going to take 12 years. I mean, it kind of, I guess, these are the kind of things, not to go into the weeds too much, but that are just making it very difficult as a utility.
Thank you, Lorna. Appreciate those insights. Let's move over to Lauren with DNR.
Hey, good morning, everyone. Thanks for the opportunity. Lauren Torgerson with DNR. I just want to say I'm learning a lot through this process. You're all transferring your knowledge, and that's much appreciated. And I think I can bring that back to my organization and create some further discussion. So I do appreciate it. Glad to be here and look forward to today's discussions.
Great. Thank you very much, Lauren. Let's see, Kevin with Mason County.
Yeah, good morning. Thank you. Really good discussion here. I think to kick things off, that kind of gets to the heart of why we're here. And it really resonates with me because at the county level, we deal with this type of stuff through permitting all the time and planned action, environmental impact statements, SEPA, and all that kind of stuff. And I think the message that I'm hearing here is, we want to find efficiency, but we don't want to necessarily leave anything out. We want to get it as right as we possibly can, but those two things don't have to be in conflict with each other. There are probably opportunities for concurrent review and being able to find that capacity to run these processes in a way that ultimately provides predictability for applicants and for us in local government. That's always nice, but also provides that assurance that we are checking the right boxes and that we're getting the appropriate level of review on these things. So I'll probably have more to say as we get more into the conversation and hear from the people that actually deal with going through the regulatory process. But I think this is a really important aspect of this conversation.
Thanks, Kevin. And we certainly hope we do hear more from you as the meeting goes on and you hear things that provoke your thinking about that. Kathleen, you made some opening remarks, but did you have anything you wanted to add here?
No, I'm good, thank you. And thanks for everybody's wonderful and participation here and honest conversation.
All right, thank you. Okay, let me keep going. Let's see, Julie Kopic with Ellensburg, please.
I'll just echo try not to shortcut, try to do some concurrent review for efficiencies, but I feel like everything I read of, things getting slowed down is a lawsuit, well, you didn't do enough due diligence here, or you skipped this review. I just feel like it's important to maintain that local control. I feel like it's important to be thorough, go through whatever checklists can be provided and make sure you're covering everything, or like others have said, I think it will just slow you down later. and possibly cost more.
All right, thanks, Julie. Things to be keeping an eye on here. All right, Joe, you're going to be speaking here in a minute, but did you have anything by way of round robin that you wanted to add?
Not right now.
All right, thank you. Glenn, how about you, Department of Commerce?
Good morning, everybody. I'm looking forward to the presentations and discussion today and tomorrow. As Kathleen was saying, we've had a very active period of discussions with the legislature and running up to that on a variety of issues concerning land use, issues within communities, even in rural areas, about not necessarily restricted to transmission, but more broadly the role of energy in rural areas. And we've also seen a growing interest in strengthening the transmission system across the West in order to develop clean energy resources, in the places where they are most productive. And in some cases that, could actually avoid some more localized land use issues if we have the transmission capacity to reach those in perhaps more remote areas. Anyway, so there's been a lot going on, and has really reinforced for me the importance of this group in terms of trying to identify ways that we can ease some of the conflicts and increase the likelihood that we have successful outcomes for everyone. Thank you.
Thanks, Glenn. Appreciate that. Dana Miller, Yakima Nation, would you like to make some comments?
Thank you. Not at this time. I'm on a later time slot to speak.
You are on later. Yes, absolutely. So it's only if you had anything else that you wanted to add right now.
Not right now.
Okay. Well, we'll look forward to your comments in just a bit, Dana. Thank you. Brendan with Ecology.
Hi there. This is a time of incredible ferment and lots of ideas around and changes around clean energy broadly and transmission in particular in this work group. And I'm hopeful that the ideas result in win-win type of solutions. As we think about this over a longer period, I think it's important to build in feedback loops where you learn from the new changes that you've made. I don't know that happens over the arc of this work group. There'll probably be just time to talk about stuff and make some recommendations and close thing up. But in the end, we might want to recommend that if there are changes that they have some kind of feedback loop, learn from the projects on the ground that will happen down the road, and continue to improve the system over time.
Thank you, Brendan. Clint, City of Richland.
Hi, thank you. I've got two comments. One is to add on to the timeframes. Not only for consideration, not only is it lengthy as we know for transmission timeframes, but there's a stacking of timeframes because typically there's generation that goes with it. So it takes not only the timeframe for the analysis, the generation planning, the financing, but then also the construction. So stacking of timeframes. Second comment is I understand that there's some legislation proposed for some FSEC changes, and I'm curious to see if there's any way that we could get an update presentation on how those proposed changes could or will affect what we're working on now. And I'll leave it at that. Thank you.
Thanks, Clint. Kathleen, I don't know if you want to respond to that right at the moment.
I can just, in summary, in terms of transmission, there's not a lot that's changing in terms of the ability for projects to opt in on the generation side. There's some new categories. Some of that is clean energy manufacturing, which isn't really as related to transmission. And for green hydrogen and renewable hydrogen as well. So those would be new categories. Not as much related to transmission. There's a part of what was in FSEC statute which was really confusing about whether or not transmission projects could opt in to FSEC. And so part of that bill is just clarifying that language, and I sent that out in December and can do that again. But the other piece that would be directly related is we do have enhanced consultation with tribes in the bill, as well as an option for up to 2 tribal members to be added to the FSEC council on a project. So that would affect all of the projects coming through FSEC, including transmission. So that's a quick summary, and I'm happy to send out more information, and I'll do that in the next day or so. We have a deadline of having it get through the House by Tuesday. So perhaps I can wait until after that and send you a summary of what the bill is at that point in time.
Thanks, Kathleen. That sounds like that would be very helpful.
Okay.
Appreciate that. Okay, we have just a few more folks to go here in our round robin. And again, I'm focusing on the folks who are the designated members and then trying to make sure that all the seats have had a chance to be heard. So Ben Blank with DFW, going to you.
Yeah, thank you. Mainly, I just wanted to thank everybody for the opportunity to be here and have these conversations. I would say just in response to, or maybe going along with the idea of the time frames and the kind of the lengthy time frames that all these things take. One thing that goes hand in hand with that, I think, is ensuring that for the siting of any project or a transmission line, that anybody that needs to be involved or should be involved, it is early on, and I think that can, it's obviously still a lengthy process regardless, but I think that helps to ensure buy-in going forward. So that's just the only additional thought I'd add right now. Thank you.
All right, thank you, Ben. Appreciate your thoughts. Anders Johnson with BPA. Anders may have had to step away for a minute. I will circle back to Anders. Let's see, Allison Brooks, how about you?
Well, hello, everybody. And I'm really sorry I haven't been part of this group. And this is the first meeting I've had time to attend. So my apologies. As somebody who has been in regulation or a regulator for 30 years, let me just quickly respond to all these concerns with environmental streamlining. So from over 30 years, I would say the best way to streamline is to get to know. No one ever gets to know. And sometimes you have a preferred alternative that has so many impacts, you just got to get to know, or you will spend 10 years at meetings and appeals. So maybe it's something that we can discuss. Honestly, I've seen projects just drag for years when if an agency has just moved their project to somewhere that may have had less impact, it probably would have gone way faster. And nobody ever, I think in America, we all talk about getting to yes, we want consensus. And I've always said, sometimes you got to get to know, not the no project, but the no, not over here. And but I do think it's something we chew on, maybe, because NEPA and SEPA were actually designed for that, and nobody ever uses them that way. So, And also, just really quickly, when we use the term environmental streamlining, my answer to that is the Port Angeles graving dock. We were streamlined right out of that consultation. And if anybody ever remembers that project, the state lost $166 million because cultural resources was streamlined out of the streamlining team meetings. So just remember to include everybody, otherwise it's expensive. And Port Angeles was another one where if we had gotten to know faster, the state wouldn't have lost so much money and the tribe wouldn't have experienced so much trauma, but we didn't. So looking forward to talking later. Thank you.
Thank you, Allison. And you are one of our speakers in the round robin panel. So we'll appreciate your hearing more from you up at that point as well. Amir from WashDOT.
Thanks, Susan. Good morning, everybody. So as state agencies on the call well know, long-term resiliency for our state has never been more important of a focus area for us. And what Nick Garcia shared reminded me that what this group is doing is such a huge part of that effort and something that we shouldn't lose sight of. Otherwise, I have an announcement of a change in WashDOT participation. Last week, I transitioned to a new position at WashDOT as our Environmental Services Director. And so I'll be rotating off, but Justin Zweifel is here, and he's our NEPA SEPA policy lead, and he actually co-presented with me a couple of meetings ago. Justin, can you pop on and just say hi so people remember who you are? And the question of who's going to be primary and secondary for the duration might change, and Justin and I are going to be figuring that out pretty soon. I'll still be engaged, with WashDOT's involvement with this group and beyond concerning CETA, but just not as prominently in this forum.
Okay.
Thank you.
Yeah, thanks, Amir, for the introduction. I saw some of you in December when Amir and I co-presented to the group on WashDOT sustainability initiatives and our right-of-way policies. Other than that, this is my second meeting, but I have been sort of following along with the notes. So glad to be here, and I'll be here moving forward. So thank you.
Thank you, Justin. And Amir, we will miss seeing you, but let's coordinate with how you want us to track the primary and alternate for this. We're happy to follow up with you on that. Appreciate that.
Thank you.
All right. I think, Anders, you had said that you were having trouble unmuting, but you didn't have any comments at this time. So let me know if
Susan, this is Lauren. I'm just chatting with him. I'm going to try to Anders, I'm going to try to unmute you on your computer Zoom login because I'm not seeing your phone number. So let me know if this makes a difference.
Hi, can you hear me?
Yes.
Oh, yeah. Thanks for the opportunity. I didn't really have anything major to add, but yeah, just would reinforce that earlier comment about the lead times being, so far out that we need to be thinking now about what we'll need in 15 plus years.
All right, Anders, thank you. And I think the last person from a seat that I need to ask about is Aaron Saylor with Columbia Riverkeeper. Aaron, are you able to join? And did you have any opening comments you'd like to make?
Hi, sure. And I apologize for being late. I had something come up last minute this morning. I'm still kind of getting my bearings, having just jumped into the meeting, but I just wanted to add to an earlier comment about with the streamlining of the environmental processes and getting to know faster. I fully agree that if the agency and if the data and everything is pointing towards a no, then I agree that we shouldn't be, it makes sense to have a streamlined environmental process. My only concern is where we're streamlining it to get to a yes, and in that process maybe not considering all of the relevant data points. We're seeing, at least on the Oregon side, new quote unquote clean energy projects that aren't as clean as maybe they're putting themselves out to be. And so I just want to make sure that in the streamlining of the environmental processes that we're taking a hard look at kind of the truth behind some of these projects, and that that doesn't get lost in the concern to speed up the process.
Got it. Thank you so much, Aaron. Very glad you were able to join us today as well. And Katie Ware had also pinged me that she was kind of in and out, and so don't necessarily, and that she didn't have any particular comments. Have I missed any other of the designated seats? Don't see any hands up. Thank you again for those who did make a comment here, and I'm sorry that we didn't have enough time to touch on everybody that's in the room, but we do look forward to your engagement here in the meeting. Before I move us on to our next agenda item, and I am aware that we are a little bit behind schedule, but it's always helpful and important to have these round robins. I just wanted to mention that in the conversation this morning, there's been a fair amount about the streamlining. So in the charter for this group, just so that it doesn't appear to or feel that this is kind of a willy-nilly thing that this group is undertaking, one of the items that this group is charged with from the legislature, it's responsibility number 3. It's on that first page of the charter. Identify environmental review options that may be required to complete the designation of such corridors and recommend ways to expedite review of the transmission projects without compromising required environmental protection. So just wanted to note, I was asked to just flag that was a charge for this group. And listening to the conversation, I think there's a lot of very intentional and deliberate intent to not jump over environmental review. So looking for creative ways to expedite, useful ways to expedite, and not cutting any corners of important review processes. So just wanted to mention that. And I see here in the notes, expedite without compromise as a really great quote. All right, so with that, let's go ahead and move on. I'd like to ask Joe to make some opening comments here, setting the context for this whole transmission line permitting conversation. So Joe, over to you.
Great. Thanks, Susan. Excuse me. Yes, thanks everyone for your attendance. We thought that it would make sense for me to give a little bit of additional context about what we're going to be talking about for the next couple of days. So I'll try to do that really quickly. First, I wanted to touch on the terminology we're using. I feel like that's been addressed a couple times. The idea of expediting and streamlining versus sacrifice of environmental cultural review. So I think that's pretty clear. Second, I wanted to sort of explain our highlight on what we are calling long distance high voltage transmission lines. And we decided that a focus on these types of projects made sense due to their long planning horizon, the complexity, and their potential for CETA compliance in the future. Due to the scale and their impact, these types of transmission projects are almost always follow the NEPA process, but they must also satisfy state SEPA requirements as well. And so they involve a large amount of interagency cooperation. That said, we will tomorrow be hearing a bit about the challenges faced by Puget Sound Energy for a project that is, to my knowledge, is not under SEPA review, but that is kind of an exceptional case. So I also wanted to point out that these long distance high voltage projects are actually, they're few and far between, as you can imagine. They take sometimes a decade to complete. And so the only two local examples that I could find for a sort of case study were the Boardman to Hemingway project in Oregon, and also a previously proposed project called Cascade Crossing in Oregon. Boardman to Hemingway is almost complete, and but the Cascade Crossing project was shuttered by PGE. But we'll hear a little bit more about that later. And then lastly, the other thing about these example projects is that they happened in Oregon, and Oregon's FSEC requires these scale of projects to be certified through FSEC. So in terms of Washington has a SEPA process, and these projects aren't required to go through Washington FSEC certification. It's an opt-in. So I just wanted to say that to keep in mind the difference between what you're going to be hearing about the state certification process of these Oregon transmission lines. So with that, I'll just quickly recap. Today, we're going to hear the story of almost successful Boardman to Hemingway permitting transmission line. We'll then hear from state agency and representatives about the role they play in reviewing and permitting transmission projects in general, and ideas for how to potentially expedite or streamline review and permitting. After this, we'll hear the permitting story of the Cascade Crossing project and similar linear energy projects, pipelines specifically, which required NEPA review and interstate interagency cooperation. And then tomorrow we'll hear perspectives on permitting from Puget Sound Energy, Pacific Core, and Idaho Power, and walk through our principles. And that's it.
Great, thank you, Joe. That's very helpful. This is in many ways, a kind of a complicated tying together of all sorts of topics. So thank you for helping to frame that up for us. I'm going to go ahead and share my screen again. This is really what Joe just mentioned here. So all I want to do is just to let you know that, again, we have a mural board set up. We always think it's helpful just to have a place to kind of capture things that you may be thinking, observations or insights. I'm going to ask Lauren if she would drop the link to the mural board into the chat so that you're able to access that and invite you to join. You may need to copy and paste that into your browser, or you may be able to link to it directly from the chat. So whichever way works for you, that would be great. And if you are not a member of the work group, we invite you to just observe as opposed to adding any content to that. But the most important thing is, of course, to pay attention to the presentations. And with that, unless there are any questions about the mural board, with that, we'll go ahead and move into the Oregon Department of Energy federal state level transmission line permitting, and welcome Sarah Esterfin, Senior Policy Advisor with Oregon FSEC. So turning it over to you, Sarah.
Great, thank you so much. So just to confirm, will you drive the presentation on my behalf?
I would be happy to, unless you would prefer to share.
No, that works just fine. Okay, let me just get it set up here. Trying to get my camera on.
While you are doing that, Sarah, let me just mention that Doug Young, who is with the Forest Service, he's the Regional Energy Program Manager. I believe he is also in the room. He is here to join the conversation about Cascade Crossing. Doug also worked on Boardman to Hemingway. And so if he is here, I'm just checking real quick. I don't know that I see him in the room, but if he is here or if he does join, he may also have some insights that he would just contribute to Sarah's presentation. All right, Sarah, out of your way.
Okay, absolutely. Thank you so much. And I coordinated with him as well. So I've got a little carve out for him. But good morning and thank you so much. I'm thrilled to be here and thank you, Joe, for reaching out. Just again, my name is Sarah Esterson and my role at the Oregon Department of Energy is the Senior Policy Advisor. I don't know if that means too much, but I'll tell you a little bit about what I do in just a second. I've been at the Department of Energy for 6 years, and I primarily work with our senior analysts. Those analysts are the ones that receive applications for energy facilities and coordinate with state and local agencies in that review and basically prepare the environmental impact assessment and recommendations to our version of FSEC, and I'll refer to them as the council so we don't get confused. So I work very closely with them, and then I play a fairly large role in our compliance program as well as rulemaking. So I'm exhausted, if you can imagine. Okay, go ahead and move to the next slide, please. All right, so for this agenda item, my intent was to present information about the federal and state permitting process that has occurred for a proposed 300-mile, 500 kV transmission line, which I'm sure you've heard of it. It is the Boardman to Hemingway transmission line. And that's a project that would start in Idaho and traverse 5 counties in Oregon to terminate in Boardman, Oregon, which is in eastern Oregon. And this project is proposed by Idaho Power Corporation in partnership with Bonneville Power Administration and PacifiCorp. Next slide, please. So I'm going to start with a brief overview of the project and its location, and then we'll highlight the overarching purpose and need, and then we'll talk about the federal and state permitting steps and status. So let's see. Okay, I think we talked about that. You can go to the next slide, please. So this shows you a close-up of some of the segments where alternative and proposed routes, where they are proposed. So on the left-hand side, this is just a, it shows you in the red line a proposed route, and then on the other side of the road is an alternative route. That's in Morrow County. And then on the right-hand side, you'll see we've got proposed route and rebuild locations in Baker County and similar in Malheur County. And that's kind of just to show some of the complexities. The project overall includes not just the 500 kV transmission line, it includes alternative routes, 230 kV rebuilds, switching station, communication stations, temporary multi-use areas that would cover up to 30 acres, temporary disturbance from pulling and tensioning sites, over 200 miles of new roads, over 200 miles of substantial improvements to existing roads. Next slide, please. Okay, and this is kind of similar, again, just kind of showing the extent of we're reviewing a proposed route and an alternative. The alternatives are fairly close to the proposed, but nonetheless an alternative that we evaluate and distinctively. Next slide. Okay, so the purpose of this project is to relieve transmission constraints, provide more opportunity for energy exchange, ensure the Idaho Power Company can meet its forecasted customer demand, and improve system reliability for future expected growth. Next slide. As we've talked about, the project has to receive both federal and state approval and has quite a complicated nexus of federal and state and local requirements that it's had to go through. So we'll start with the federal requirements. So because this project is proposed on federal lands and based on the scope of the impacts, review under the National Environmental Policy Act was required. And the Bureau of Land Management was the lead agency. They were responsible for developing and issuing the environmental impact assessment, which was issued in 2016, and then the record of decision was issued in 2019. And then additional federal steps beyond the NEPA process that were required were a right-of-way approvals and executed memorandum of understanding through Section 106 with Bureau of Land Management. Special use authorizations were required for impacts or access on Forest Service and Bureau of Reclamation land. Right-of-way approval was required from Department of Defense. Consultation with U.S. Fish and Wildlife Service was required for Endangered Species Act. And then removal fill Section 404 Clean Water Act approval from Army Corps was also required. And then on the next slide, I believe we have a status summary. This graphic was obtained from a website that Idaho Power maintains, just to give them credit. So you'll see up on the top bar the time frame of when things started for some of these federal approvals in July of 2008. And then you can see almost all of those federal permits and approvals that I just walked you through have been complete, except for the use authorization from Bureau of Reclamation and then the Section 404 Clean Water Act. So I think this is where, because we have Doug Young, you know, Doug, if you're interested in providing any input on the experience that you've had at the federal level with ESA or otherwise.
I think I'm on. Can folks hear me?
Yes.
Hi, everybody. Hi, Doug Young. I'm the Regional Energy Program Manager, Forest Service. We cover Oregon, Washington, out of the Portland office. I previously worked with U.S. Fish and Wildlife Service and at times was lead for my agency out of the Oregon State Office for endangered species, sage grouse, and other issues with Boardman to Hemingway transmission line project. Now with the Forest Service, I was involved with the NEPA analysis that Bureau of Land Management was lead on. There were 4 federal agencies involved, and BLM was anointed the lead for that process, and we all relied on that final environmental impact statement for our own final documentation. So in our case, we signed a final record of decision, which provided Idaho Power instructions on what our expectations were for various subsequent stages of the process leading up to some sort of notice to proceed. But we started in the early 2000 or mid 2000s, late 2000, 2005, 2010 period, I think, working with Idaho Power. And we finally issued our easement in 2019. So it's a process that took a long time, had other agencies in the lead, had challenges. I don't know if I heard this real specifically in the presentation that just happened. There was alignment challenges between, I believe, the federal NEPA process, endangered species process, and the state process. And some of that, and I'll just be really brief in these reflections with Boardman to Hemingway, some of these challenges were based on really early agreements and assumptions that these teams that Idaho Power set up and the frameworks for analysis and agreement on how we would categorize impacts and then do compensatory mitigation to fix those by resource areas didn't play through for that decade or so it took to get to the final analysis and licensing pieces. We had changes nationally in leadership, and that changed different things that affected those assumptions. And we always had a tension, in my mind, between the state process and the federal process. What should precede the other? They kind of proceeded in parallel, but it seemed like one or the other really should precede the other, so then you could mimic it with the second process. Endangered Species Act, I guess my observation is this was a challenging project, not necessarily for endangered species, but a species that could be listed under the Endangered Species Act, and that was sage grouse. And it was one of multiple projects throughout Western United States where Bureau of Land Management and U.S. Fish and Wildlife Service were trying to create similar frameworks for analysis and mitigation. And those didn't, once again, line up with the experience and intent of the applicant, and didn't necessarily perfectly align with the state of Oregon's compensatory mitigation policy. And so there was challenges within that aspect of citing, agreeing upon impacts, and then talking about how we might mitigate our way through all of that. That was my quick observations on B2H. Thanks.
Thank you so much, Doug. And you said, have you been, how long have you been involved in this project, in the regulatory review?
Originally with Fish and Wildlife Service back in around 2010 or so when the project got started, all the way through when the Forest Service issued its easement and still now as we're working with Idaho Power on the Forest Service compensatory mitigation package, and ultimately review of the plan of development and other documents necessary for them to receive the Forest Service's notice to proceed.
Great, great. I hope we can connect outside of this presentation as well to talk about lessons learned. And so thank you so much for helping with this. Okay, so next slide, please. Now we'll move into the permitting requirements at the state level in Oregon. So for this project, a permit is required from the Energy Facility Siting Council. And again, I'll refer to it as council, which is the governing body of the Oregon Department of Energy Siting Division, the division that I work for. And a permit from the council is required because there's a statutory threshold for transmission lines that would then trigger a state level permit. And those triggers are about the voltage of the transmission line, the length, and whether it would be located in or cross more than one city or county. And so, of course, this project is greater than the 230 kV, which is one of the triggers. It's more than 10 miles and it's located crosses 5 counties. So it triggers all 3 and is then state jurisdictional. And our process, which I think seems similar to the SEPA process, is intended to be a consolidated one-stop permitting process. And that incorporates all of the local land use requirements. It also it's intended to incorporate all applicable state statutes, rules, ordinances that would apply to the construction, operation, and or retirement of the facility. Next slide, please. Okay, this is where, so we just jump to the next slide. I move things around and then we'll come back to that. So I wanted just to point out under the Oregon state permitting process, there's 16 standards that Idaho Power is obligated to demonstrate compliance with through the permitting process. Our process is referred to as an evidentiary process. So they would have had to provide facts and evidence to support their analysis of whether they believe they can meet these 16 standards or requirements. And then there's numerous other state agencies and rules that get state agency rules and statutes that get pulled in. Some examples are a noise control regulation that's under the Department of Environmental Quality. There's removal fill law under Department of State Lands, and those all get folded in to the Oregon state permitting process. So for this project, there were 2 other state agency permits that were incorporated, and that was the Department of Fish and Wildlife's fish passage law, and then Department of State Land removal fill. So it's effectively 3 permits in one, and then a compliance evaluation of, a number, at least 5 counties and probably 5 or 6 state agencies. All those requirements are part of the process. And let's see, so our process, we have a statutory obligation to coordinate with state and local governments to identify what all those requirements are, and then we have a process for making sure an applicant then evaluates those in their application. So just a couple points on the council. The council is a 7-member governor appointed board. And again, we report and make recommendations to that body for whether to approve or deny a project based on evidence that's been evaluated to decide whether this applicant can satisfy all the applicable requirements. Okay, next slide. Okay, so this is just a quick graphic of our process. It's a 7-step process. For Boardman to Hemingway, they are at the contested case process. That's the red chevron, which is our version of a lawsuit. And once the project goes over to this contested case lawsuit. It's where issues are being contested. It does get handed over to a third-party attorney. And so it's out of our hands while we're a party to this lawsuit. It is an independent body that's making the decision on whether these issues can be resolved or whether they're so severe this third party recommends the project should be denied. We are almost through that process. It's expected to conclude around the summer, and then we have just one more step after that, which is then we take it all to council for their ultimate decision. And then I do apologize if you want to go back to that slide with the schedule. It's just 2 slides up. Oh, right there. Yeah. So this is an overall schedule of the federal and state permit process. So if we go over to 2022, you'll see, and again, this is from Idaho Power's webpage, but they're forecasting final decision through the state process this summer, which I think that's on point. And then it shows, you can see here that the federal process notice to proceed is expected in early 2023. And I think that concludes the set of information I was intending to present. So I'm happy to answer any questions if you have any.
That was great, Sarah. Thank you so much for that. And Doug, for your comments as well. I'm looking to see, we do have a few minutes for questions. Again, inviting people to hop onto the mural board. And if you have any insights or observations, we'd love to have you note those. It will be in that lower half. I think it's yellow on the yellow colored little sticky notes. But honestly, if you put it anywhere, we'll get it to the right space. Are there any questions for Doug or for Sarah about Boardman to Hemingway? Looking for hands and also looking in the chat. I don't think I've seen any questions raised in the chat. People might just be so overwhelmed with the amount of detail there in that project, and not in your presentation, but it's a complex project. Clint, I see your hand.
Yeah, I was just going to say thanks for taking charge on this project and helping to get it complete. It's 20 years in the making. It's scary that it takes that long, and I appreciate the challenges that the team ended up doing and accomplishing, not only taking on federal, but then also state and multiple county issues. So what we've been talking about here is complexities generally within states, but this is definitely one of the extremes and a great example of the challenges that transmission projects face. So thank you.
Thanks, Clint.
Susan, could I follow up with that?
Yeah, absolutely.
That really resonates with me and reminds me, digging up some Wayback Machine here, it was a long process. A lot of these linear energy projects take long time to work. I've worked through my career with Fish and Wildlife Service and Forest Service now on probably 15 or so multi-billion-dollar mega projects, these linear projects that might be interstate or intrastate. And what I've seen work best is those that work, they are not speculative. They're ones that you can tell from the get-go that they are players and they're going to get it built, and they move fast and they're really organized, and they put a lot of emphasis on staffing up and encouraging the team that works on these to staff up with the most experienced people possible, and just carve out time and commit those folks for years and years and years, because it takes a long time, and you want those experienced, risk-taking, I guess, what are some other adjectives here? Folks that are newer in their careers and they're going to be trained with cookie cutter approaches probably aren't the ones you really want on these kind of big, important, nationally recognized transmission line or pipeline projects. So the challenge is to move fast enough that you retain those folks throughout the process. So that is really challenging. There's so much turnover when you talk about a B2H type project with 15 years later, what were we agreeing to in our mitigation framework in 2010? That makes no sense when I'm the person now writing the special use authorization for the Forest Service. And so they don't match up. You gotta move fast. You gotta have the really creative, experienced folks working on them for a long period of time. Thank you.
Thanks, Doug. Appreciate that and that kind of lesson learned there. We do have a question in the chat about whether or not BLM is always the lead agency, but before maybe speaking to that, Sarah, do you have anything you wanted to add to Clint's comments?
Only that I, completely agree with Doug. I mean, that is the biggest takeaway from my perspective as well. And he's clearly been involved with the project longer than I have. But you have to have the right resources. And it's just a real challenge at the state government level to make sure that happens, because staff retention is difficult. So I don't know how we can solve that problem, but I think it's good to acknowledge the key contributing factor.
Thank you, Sarah. Does anyone want to take that question of, so Joe had asked, is BLM always the lead agency if there are other federal agencies affected? Allison responded to that from the Section 106 perspective. So just wondering if there is anything else, either Sarah or Doug, briefly about whether BLM is always the lead on these. And then we had one other question in here that looks like it might have been answered, but if you could speak to the BLM one as the lead.
I put something in the chat box, Susan, and I think
I see it.
I think what I just typed in there, which I asked my legal counsel to provide some input on this. So this is kind of mimicking what she gave me. That Forest Service is authorized to issue right-of-ways on Forest Service lands. This is a bit different than when there are multiple federal agencies and it's a pipeline project. And then I think Mineral Leasing Act takes primacy and BLM then has the right-of-way responsibility. And I'm getting those a little bit confused in my mind. But I think for B2H, the reason BLM was lead is they had the primary length of line on there with little snippets of Forest Service, Department of Defense, etc. That we just relied on BLM's process and expertise to be our lead for the NEPA there.
Got it. Thank you, Doug. There isn't one other question here, and then I think we'll probably go ahead and wrap this up and head to a break. But there was a question about
Susan. This is Allison. Can I just add on to that answer and just say, for lead agency, and as I said this in my answer, the federal agencies have to agree to who's the lead agency. So you will see sometimes federal agencies saying, nope, I'm going to do my own process. I don't want to have you as the lead. Same thing when you have two state historic preservation offices. We can agree to have a lead SHPO, so to speak, but a lot of times you have to consult with both of us. TIPOs can do the same thing. Tribal preservation offices can designate a lead TIPO, but sometimes they don't want to do that for various reasons. So it's not I guess where I'm going, it's not an automatic decision.
Got it. Thank
Susan,
you. Yeah.
Also, I wanted to just jump in here and ask for our BPA. Is BPA always the lead agency on the federal side? So in our state, if we were looking at a project on the BPA system, how would that work?
Anyone want to take that?
Well, can I ask a question? When you say lead agency, do you mean for the project or for the environmental review process? Because it might be BPA's project, but let's say, so BPA has to go through 106, but then you need a Corps permit. So now the Corps has to go through Section 106 and NEPA and everything else. So the question of who's the lead agency, I think, needs to be clarified as to what are you actually asking?
So perhaps Anders, if you can help us out here.
Anything to add, Anders? That there might be another issue with muting and unmuting. So, Lauren, I don't know if you can give a hand to Anders to see
Let
if
me
we
see. Yeah, let me see. How about now, Anders?
Hello?
Yes.
Okay. Yeah, my understanding is that on transmission projects in the past where it was a BPA project where we were the owner and the project sponsor and the one building it, we were generally the lead agency for NEPA, and then there were other cooperating agencies as appropriate. And I think on projects where we, where someone else was the lead, we may have been a cooperating agency in the past.
Thanks, Anders. Kathleen, did that answer your question?
It did, but it is a really good question. I think if we can somehow figure out how to get information, maybe we'll hear this as well from our utility partners, because they would be the ones who might work in that nexus outside of BPA too, what they found. And I know we have some more time tomorrow for them to talk as well.
Great. Yes, we do indeed. Thank you, Kathleen, and everyone for that. I just want to mention briefly, Joel posted here in the chat wondering about if there was a proactive outreach campaign to get awareness or solicit feedback. Do any of you, Sarah, Doug, can you speak at all to the comment or to the public process for this?
Is that, I'm sorry, is that question in the chat?
It is in the chat. Yep. And it's above the power line answer from Doug. So take a look at that, and maybe if you have something that you can speak to, it asks if the formal comment periods, if they were the primary mechanism, or if there was a proactive outreach campaign.
Yeah, at least for the state level, it would have been like procedural requirements during public comment period that we would have had to notice. And I would say in order to try and like increase participation opportunities, all comment periods were, like 3 times what would be normal. And half of that was upon request from people trying to participate, but we started with a bigger time frame and then gave more upon request. And then, I do think that Idaho Power did other things that weren't required through the state process, but I won't speak to that.
All right, thank you, Sarah. Okay, we are just a little bit over time. However, seemed like a very important conversation to try to wrap up. There are going to be more conversations as we get into Cascade Crossing. There may be other crossover kinds of issues that get identified. So encourage everybody to think about that. So I did have a question. Can we screen share the last process slide, the one Joel is referring to? I'm just gonna, is this what you're speaking about, Stu?
No, before that.
That one?
That one, yeah, because that's got the public comment part in there.
Okay. All right, and Amir, I think your hand was up and then down. So unless you alert me otherwise, we'll just go ahead. And did you have something?
I just had a really brief question for Sarah. So I saw that the alignment coincided with Interstate 84 in places, and I'm just wondering if Federal Highway Administration ever had to get involved.
Not through the state process. I mean, we would have had state Oregon Department of Transportation, and then roadway permits, heavy load permits, that type of thing. And those would just be something, it wasn't like a substantive review through the permitting process, just a permit they would have to go get from ODOT before construction.
Okay, thank you.
All right. Well, thank you again, Sarah and Doug. Really appreciate your presentation, your participation, your response to the questions. And I hope you'll be able to stick around. Doug, I know you're going to for Cascade Crossing, and Sarah, to the extent you're able to, I'm sure it would be valuable for folks to have you still in the room. So I'm going to move us ahead here, and we are going to go ahead and take a break. That says 10:20, but don't be fooled because it is already 10:21. We do want to give you an opportunity to take a brief break and come back. So let's plan on, Kathleen, is 10:30 okay? So we're shaving a minute or so off the 10. All right, so we'll frame this up for 10:30. Please be back here. I think we'll be able to make up the time. And again, really appreciate the conversation. So enjoy your break, and we'll see you at 10:30. All right, everyone, about one more minute and then we will get started again. So if you could please, yeah, if you're in the room, let me know. Thanks, Erin, for turning your screen on so I could see you. If others would do the same, either raise your hand or turn your screen on, and then we'll know if people are back and ready to go here in a minute. Thanks, Glenn, Nicholas, appreciate that. And Will, thank you. All right, let's again take a look. I thank you for those who turned your cameras on, or otherwise let me know that you are in the room. We're about ready to get started on the state level transmission line permitting conversation. And just to frame this up a little bit, this is what you might call, well, it's an invited panel, if you will. There are a number of people that are either members of the work group or are not members of the work group, but are very involved in the state permitting process, and we wanted to be sure to get their perspectives. So what we did is invited someone from ecology, from the Snoqualmie Indian Tribe, Yakama Nation, the DAHP, DNR, and DFW, and all of those acronyms I believe are spelled out on your agenda. But we invited them to just provide a few comments. So not a formal presentation, but we'll do a essentially what feels like a round robin. We'll walk through, give each of those folks a moment to provide their perspectives. We ask them to speak to a couple of questions of what role do their agency or their tribe have in permitting transmission projects, and what do they see as the biggest challenges or opportunities for the expediting review and permitting of transmission projects. So we're asking the speakers to speak to those things. And what I was planning to do here is just walk through the list of names that are on the agenda and essentially invite people to speak in that order. We did have someone initially who was going to be speaking from FSEC, Washington FSEC. They were not able to participate today. As we are inviting them, the panelists, to speak to their perspectives, we invite you to provide any notations of your insights and observations in our mural exercise using that same link that Lauren had provided earlier in the chat. So for you, what are your observations and key takeaways, and what recommendations might you have hearing of the experience and thoughts, observations from the panelists? So that is what we are framed up to do here. So with that, I'm actually going to stop sharing my screen, and we're going to go to our speakers, starting first with Brendan with ecology, and then we'll go to Stephen Moses with Snoqualmie Tribe. Brendan?
All right, thank you, Susan. I'm going to speak today not just to ecology permitting for transmission lines, but a couple multi-agency processes that can come up when dealing with linear projects, including transmission lines. So SEPA. First, I want to talk about the State Environmental Policy Act, or SEPA. If transmission line projects need state and local permitting, SEPA will be required. Linear projects, by their nature, will likely be multi-jurisdictional, so we need to determine who will be the SEPA lead agency responsible for review. Lead agency is the one responsible for the review of the total proposal under SEPA, not just the portion of the projects that they have permits for. Other agencies then use the SEPA review for their decisions. SEPA lead agency depends on the proposal and sometimes who the proponent is. Local and state agencies are lead for their own proposals under SEPA, so we see PUDs as the lead for their own transmission line and substation proposals. That's fairly common. The proponent is a private utility. The SEPA lead is often city or county with the largest project footprint. SEPA does have some options for lead agency. Agencies can, but aren't required to work together as co-leads, jointly responsible for the review since linear projects cross multiple jurisdictions. Lead agency can be transferred from one agency to another if all agencies with jurisdiction agree. When the proponent is a federal agency or another federal agency does NEPA review of a proposal, there are some options for how to integrate NEPA and SEPA. Well, it's possible to do separate NEPA and SEPA reviews. That's not very efficient. And SEPA encourages combining reviews where possible. One option is for state and local agencies to participate in NEPA review as a cooperating agency to make sure their issues are addressed in the NEPA document. Then when NEPA is complete, the SEPA lead agency can adopt the NEPA document to meet SEPA requirements. If there are additional issues in SEPA review not reflected in the NEPA document, the SEPA lead agency can build on the NEPA review by adopting and then issuing an addendum or even a supplemental EIS if needed. Finally, SEPA also allows for joint NEPA-SEPA documents with both federal and state co-leads. This is less common, and sometimes differences in federal and state procedures make this hard to pull off, but it's not entirely unprecedented. If SEPA is one complex multi-agency process, I want to mention another one. First, think about the nature of the landscape in Washington. If you're going to do a linear project of any length in Washington, especially Western Washington, you're going to run into water. I once worked on a pipeline project with over 300 wetland and water body crossings. While transmission lines won't have that kind of in-water work, or at least that amount, there are still access roads and other on-the-ground footprints that get into the aquatic permitting arena. In Washington, we have a mechanism for coordinating federal, state, and sometimes local review for wetland and in-water impacts. We have the Joint Aquatic Resources Permit Application Form, or JARPA. It's developed over 2 decades ago and maintained by our colleagues in ORIA, the Governor's Office of Regulatory Innovation and Assistance. JARPA is a single application that can be used for more than one agency. JARPA is used primarily for applications to federal agencies like the Corps of Engineers for Clean Water Act, Section 404 permits, and the Coast Guard bridge permits, and state agencies like DNR for aquatic use authorizations, and Department of Ecology for Clean Water Act Section 401 certifications, and sometimes for local government shoreline permit applications. JARPA can be a helpful tool for when multi-agency permitting is needed due to the in-water or wetland work. You know, there are other specialized ecology permit requirements that can be needed, like construction stormwater permits, or sometimes, depending on location, that can be contaminated site cleanup issues. But I primarily wanted to cover the 2 multi-agency processes, SEPA and JARPA. So the challenge, I guess, is how to leverage these multi-agency processes to help with the coordination and sharing of information.
Thanks, Brendan. Appreciate your comments. I'm just going to move right on to the next speaker here. And I'm also going to just make an observation that looking on our agenda, we had another break scheduled at 11. And if folks are starting to think that maybe they won't need that, then we might be a little less time compressed for this particular part of the agenda. So maybe give that some thought as we make our way through here. Our next speaker is Stephen Moses with the Snoqualmie Indian Tribe. Stephen, we invite your comments here.
Yeah, Stephen Moses, T. Stotts, the Qualby Judd. Utigwiti just Swalti Sahel, Utigwiti Judd Twalti Suchas. Stephen Moses. I'm a member of the Snoqualmie Tribe. I'm the Director of Archaeology and Historic Preservation, and I want to thank everyone for inviting me to speak to the group today. As I mentioned earlier, for those that were here, I've been involved in cultural resources since 2005 for the Snoqualmie Tribe. I've been managing the program for just over 10 years now. I've developed the project, the department and program primarily through increasing our ability to track and review projects. When I first started, we reviewed approximately 200 projects a month. We are up to, on average, 1,000 projects a month. We review projects from Whatcom County down to Pierce County, Island County, the San Juans, Clark County, Kittitas County, and part of Chelan County. It's me and my staff of 3 other people that review these projects. So when I mentioned earlier, I don't like the word streamlining, we're already dealing with an influx of projects that we need to triage to see if we have cultural resource concerns. And then also coordinate with our environmental department to see if they have environmental concerns, and then determine if we need to join our comments together or provide separate comments. One of the things I want to make sure that I did mention with the thousands of projects that we review, typically there's only 3 things that I look for in any project. That's the location of the project. Cultural resources or cultural resources, no matter what your project is or where it sits. So no matter what the project is, we look at the location, whether it's an archaeological site, an ethnographic village site, a historic site. After we look at the location, then we look at whatever the scope of work is. Obviously, looking at all the projects we do, there's all sorts of different activities, from invasive plant removal to redirecting rivers, to SEPAs, which are by far the most common things that we look at. We also review applications for subdividing plats. So once we look at the scope of work, who's doing the project, who's paying for it, what permits are needed. As we've been talking about with all these meetings, who actually is trying to get the project done makes a really big impact on how the process moves forward. Each agency, whether it's state, federal, or local, does things a little bit differently. I work on average with about 30 different federal agencies, about 25 different state agencies. I don't even know how many cities. And that's not including, when we work directly with like PSC, who's a large utility company, not really, a part of the governmental structures of anyone, but, we do work directly with some of those large companies directly. The other thing that I want to convey that people don't always realize, time is money. I definitely understand that, business degree. When tribes take an interest in a project, it's not just for that duration of the project. We're involved, whether it's for environmental purposes, whether it's for culture resources, whether it's even political, or it's an issue of sovereignty. We are invested in an area that we've lived in, archaeologically proven, about almost 13,000 years. So we have been here a very long time, and we're going to continue to have an interest in the areas that are affected by these projects, whether they're transmission or anything. So one thing that, as anyone that's ever dealt with any of the cultural resource processes knows, the government, whether it's state, federal, sees a finality in a project when permits are done, when mitigations are met, if an MOA, has run its course and everything's committed. That's good for y'all's paperwork, but we are still concerned about the impacts to that location. So the point is, tribes are in this for a much longer period than any agency. So when we take the time to, to comment, be a part of our process. That's part of what we're doing is we're continuing the work that our ancestors have been doing for millennia. The other thing that I just want to briefly touch on, I was involved in some of the roundtables for the changes to the SEPA process a number of years ago. I can tell you that went horrible from a tribal perspective. Tribes were called in late. We were bullied by various groups. We were told by people that sit on the Small Business Association, the city group, that cultural resource and archaeology don't matter. Tribes have no interest or concerns, and that was only like, Allison could probably correct me, but like maybe 6-7 years ago. It was not that long.
Yeah, it was brutal, Steve. It was brutal. But the best line was the lawyer that's told us, if we require archaeological surveys, it will raise the price of food. I think that was the classic.
Yep. I remember that. And it's I think the last point that I want to touch on that I mentioned at the beginning is my main focus through my work here, besides learning, is having cultural resources at a bare minimum respected the same as every other resource that's concerned. I don't think that's asking a lot, but for so long it is considered at the bottom. It's always fish, trees, money, gas, hydro before cultural resources without fail. And so I'm going to keep harping on it, as I do with lots of other people. So this is nothing personal against anyone. I can talk a lot, so I will stop now. Thank you.
Thank you. That's really helpful, Stephen. Appreciate your comments, and yeah, those are very thought-provoking. So we're going to follow with Dana Miller with Yakama Nation. Dana, invite you to make some observations about your role and your experience in permitting.
Okay. Nichmaiski, Minaimo, Ko and me Hatwai. Aunash Kayak Asinwet, Ichi Shiapo Tamanwet, Ichi Shiapo Timash. Paya Atau. Chi Kut Nami Kut Slama. Good morning. My name is Dana Miller. I'm tribal counsel for Yakama Nation, and I've got a few words I'm going to speak for today. In preparation for today's discussion, I requested comments from the Yakama staff who work with the state and federal regulatory agencies in several programs, including culture resources, environmental restoration, and legal counsel. Looking at the next decade of increased development activity is concerning to the Yakama's resource protection, because there are already so many applications considered by tribal culture resource staff. It is already a significant workload and will be more difficult on an expedited basis. The Yakama Nation's treaty territory includes 3 unique land designations: the reservation, ceded land, and the usual and accustomed areas. In total, treaty territory where the Yakama Nation exercises reserved rights exceeds 10 million acres in central Washington, following the Cascades and the Columbia River. Several concerns emerged in regards to FSEC's process in relation to the State Environmental Policy Act. Specifically, I heard that Yakama Nation struggles to get meaningful consultation with the FSEC on a government-to-government basis because their process is limited by ex parte rules that do not allow FSEC to meet with tribal governments in consultation during an application review. Additionally, the FSEC review process is faster and has exemptions from some SEPA requirements. Often when issues arise, the applicant is directed to resolve the resource protection issues with the Yakama Nation. In that case, the government-to-government posture is substituted for a compromise directly with the applicant proposing the harm to cultural property. An expedited and delegated relationship is not an appropriate review for traditional cultural properties, TCPs. Concerns and cannot replace consultation between sovereign governments. Elected tribal leadership needs to be able to express its concerns on threats to TCPs created by technical aspects of a proposed application because the application is the basis for the resource threat. If FSEC only consults with tribal leadership generally about process or in an abstract, then the FSEC is not hearing how an application might actually damage a ceremonial or cultural feature. Under Yakama law, the TCP information is defined by its relationship to sacred and sensitive religious ceremonial and cultural practices is confidential. The tribal leadership has a duty to protect these TCPs that have been here for over thousands of years. The FSEC process lacks confidentiality to protect the TCPs and is denied requests by the Yakama Nation to conduct confidential consultative proceedings in the past. Applications are reviewed in public hearings and archaeological surveys are published on the website with minimal redaction. Future FSEC review needs to take a more active role in its government-to-government responsibility by helping to coordinate potential avoidance, minimization, and mitigation solutions through tribal consultation. Under SEPA, the Department of Archaeology and Historic Preservation's determinations are given considerable weight and consideration, but the FSEC process can minimize the DAP expertise and cultural resources. DAP is not a member of FSEC body, which makes conveying tribal concerns regarding archaeological professional standards, the proper application of cultural resources law, the ethnographic information challenging. Again, it is unclear how much of these professional standards are required to be in-house with the FSEC versus getting delegated, often the applicant and only discussed in public hearings. Typically, a 30-day comment period is allowed for project applications. Pre-application notices frequently do not include enough site details for cultural resource protection comments that fully consider the unique challenges like archaeology, geology, and project components for resource protection at a proposed site. There are differences between what federal and state law define as protected resources, but tribal government comments are driven by what actions are actually necessary to protect the TCP based on inherent features and specific application proposal. The tribal staff needs sufficient time to make useful comments, and this schedule increases what tribal leadership needs to be involved due to the increased concern for the resource. Tribal government needs notice of application as early as possible with the complete enough information to actually consider impacts. Whichever lead agency is designated must be responsible for ensuring that notice is provided to tribal government point of contact, and all non-agencies should be following up to ensure this compliance with application concerns. In summary, meaningful consultation on a government-to-government basis is a process that must occur early, have enough information to address substantive concerns, and needs to have the ability to lead the resource protection being implemented. Thank you very much.
Thank you, Dana. That was a lot of good information, a lot of detail, and we appreciate that. I'm sure that will invite some real conversation later. We have three more folks that we are inviting to speak, so I'm going to go ahead, unless I get a signal otherwise, or Kathleen from you or other members, that because we just had a break, that we'll go ahead and utilize our 10 minutes from 11 to 11:10 and provide an opportunity for, again, around 5 minutes for each of our remaining speakers here. We won't have a lot of time for Q&A, but really do encourage people to drop things into the mural board. So with that, and not seeing any wild objections, and Kathleen, you're nodding your head for the time, let's go ahead and move on. Again, Dana, thank you for your comments. Let's go ahead to Allison Brooks, please.
Well, thank you. I'm Dr. Allison Brooks. I'm your State Historic Preservation Officer and the Director of the Department of Archaeology and Historic Preservation. Let me start by saying our GIS system has 37,000 known archaeological sites on the system, and that is with only 2% of Washington State surveyed. So if you're doing a project along the Columbia River and you say to me, where's the site? I'm going to answer, you're on it. And that is for Columbia, Missouri, Mississippi, Connecticut, any river system, you're on it. So just be prepared. And I see Clint from City of Richland smiling. I think he knows. Tri-Cities knows well, right? We had the ancient one in Kennewick that we fought over for 20 years, 21 years, Dana, until we got him back to his people. So remember, there's 37,000 sites with 2% of the state inventory, which tells you how much more is out there. We also have information on 700,000 historic buildings. We have thousands of pieces of information on cemeteries and burials. So cultural resources are everywhere. And that includes what we call traditional cultural places and sacred places. So the federal government issued an executive order on sacred places, and they confirmed Secretary Holland at Interior to run Interior. We now have Chuck Sams III, who is running the National Park Service, and that has raised expectations for the tribes that the feds are going to take a higher standard of care on cultural resources. I will say, since Dana and Stephen are on here, that we are discovering there's a real tension now between the federal government's promises on sacred sites and the federal government's move towards green energy. I know, Dana, you're probably shocked, right? Federal government hasn't kept their promises. Remember, I've seen this movie. So the reality is right now the tribes and our agencies really caught in this strange tension between two promises that the federal government has made that are very difficult. At the same time, the Governor Inslee issued Executive Order 2102, which is an executive order that requires any state with ground disturbing activities or construction go through a higher level of cultural resource review process that also includes identifying sacred sites and looking to ways to avoid, minimize, and mitigate harm to those sites. So the first piece being avoidance or minimization. I won't talk about SEBA because I think Stephen said it the best. We all came out of that process, and I know Don Vivian is on here, feeling pretty beat up and hearing things that we never thought we'd hear. And the problem with SEPA for us is our agency will ask for an archaeological survey and tribal consultation, and cities and counties sometimes just won't do it, which then creates a bigger problem later on. They're not required, cities and counties are not required to have archaeological or cultural surveys done under SEPA, not the way Section 106 requires it, and that has created a multitude of problems. Our big player in all this is called Section 106 of the National Historic Preservation Act, and that is a process that requires federal agencies to assess the impacts of their projects on what's called historic properties. And that's any property, any site, object, building, structure that is eligible for listing on the National Register of Historic Places. So Kathleen asked, who's the lead federal agency? And I answered, who knows? And that is what our life is, basically. The feds can decide a lead federal agency. The feds can decide not to have a lead federal agencies. And we have to consult with multiple federal agencies on the same project. That's not, I mean, fortunately, it's not that common, but it does happen if the Corps decides they just want to do their section and you have, you know, another agency doing the whole project. So back to Stephen's point on the number of projects, we had over 15,000 projects come through our agency last state fiscal year, and this fiscal year before that was 16,000. And we have 5 archaeologists on staff, 6 if you include me, 2 physical anthropologists, and then 4 built environment people. So we are what's known as a micro agency. Because we have a very substantial GIS platform, we can usually turn around a review in 3 to 5 days. Rob Whitland, the state archaeologist, knows the state so well. He can flip you a response the same day. But we require all documents related to tribal consultation. So we check the federal agencies. And the reason on state agencies is because we've been lied to so many times. We had one case, and Dana, you'll appreciate this, where we had an agency say, oh yeah, I called the Yakima, and we checked with the Yakima and they called the receptionist. So we, our belief system has been harmed. So we actually require all agencies now to actually file tribal consultation documents with us. We've actually done that since about 2005. Also, we will not sign agreements anymore. Since over 20 years, we do not sign what's called memorandum of agreements or MOUs before a tribe signs. So the tribes have to give us a release. Either they sign first or they send us an email saying it's okay if we go ahead and sign without them. It's really forced tribal consultation. But the emerging pieces that really haven't been front and center before are the issue of sacred places, sacred sites. We really haven't, unfortunately, they were not considered until probably just, I don't know, when we issued our first executive order. And I would say with the coming in of the Biden administration, they have higher profile. And the reality is these need to be avoided. So we have a lot of tensions that we work with. Tribes and DAP have very little staff for the amount of work coming in, and we all just try to do our best. But again, I want to reiterate what I said earlier. Sometimes everything I think would go faster if you just looked at an alternative and said no. And sometimes even the preferred alternative, maybe you just have to say, no, I need to go to another alternative. Because if you have a huge burial area or sacred sites or anything else, you will spend years negotiating the mitigation or the avoidance, as opposed to just avoiding those areas altogether. So I'm open to, with that news, I'm open to any questions you may have later on.
Thank you, Allison. Appreciate that. Again, so much great information. And I'm wishing we would have had all day just for this panel as well. Every one of these topics so far this morning have really been excellent. So thank you, Allison, for that. I'm glad you're going to be sticking with us. So we have 2 other speakers to get to, hoping to be able to wrap this up here in another 10 minutes or so. Scott Nelson first with DNR, and then we'll go to Ben Blank with DFW. So Scott.
Good morning, everyone. My name is Scott Nelson. I'm the Rights of Way Program Manager for Washington State Department of Natural Resources. And I'm here speaking primarily as a property owner, landowner, and then dealing with your projects and those rights of way issues. One of those, as we've heard so eloquently with SEPA, your project may trigger SEPA on its own, and DNR can't grant you the easement you need until that SEPA is complete. And there's oftentimes the NEPA has been completed, but we cannot always accept your NEPA to meet our SEPA standards. So getting us involved, getting us early so we can share with you what we need in your NEPA to meet our SEPA speeds up your project quite a bit. You'll also hear us asking about your funding. As mentioned before with the 2102, there are certain situations your project funding may trigger a SEPA on its own to meet that requirement. And so we're gonna be reaching out and saying, hey, how is this project being funded by? And that's a requirement. Another critical thing is you go to the county GIS layer and you see state lands, but DNR is so much more than just state uplands. We have uplands, aquatics, natural resource conservation areas called NRCAs, and natural area programs. And each of these are different components within DNR. NAPs and NERCAs have much more regulation, protection, and stringent requirements before the granting of easements over them. We should be able to provide shapefiles of our trust lands and these NAPs and NERCAs to your project, to your utility well in advance, so that you know what your project is encompassing. As we said before, maybe the best answer is no or an alternate solution. If your project is going down the middle of a NAP or a NERCA, that may be the best option because, again, trying to get an easement across these very protected areas guarantees that your project's going to be delayed, possibly significantly. We also may have conservation easements tied to how we acquired the land, RRC, which would require your project to purchase equivalent land adjacent to our NAP or NERCA that you have to provide to DNR to mitigate and offset your project. And if you consider what that expense could be, having to buy half an acre, an acre, or 5 acres, and it has to be adjacent to our land, can get very expensive very quickly. The last thing I want to share is how my thoughts on streamlining the process. We have a great relationship with BPA where we have pre-agreed to easement language. It's already determined. All the bugs are worked out. BPA needs an easement. It's real simple. There's no great discussion of every single term, and not every easement is one-off. You can also do that now. Reach out to me. We agreed to that language statewide, at least for DNR uplands, and your project, and your staff know what the language is going to be. And it's not the haggling back and forth of every single term and condition, insurance, indemnity, waste. All those things are identified, worked out when time is not a critical issue, so that when you're ready, all of those things are set and you're ready to go, and it just speeds up your process quite a bit. Hope this helps, and I look forward to working with all of you. Thank you.
Thank you, Scott. Yeah, very helpful. We're noting that suggestion that you have. And if people haven't been dropping stuff into the mural board, please do that. I know that that'll be one that we'll drop in as something that we heard from you, Scott. So thank you again for that. All right, let's hand it over to Ben Blank with DFW for his thoughts about role and possible challenges and opportunities.
Yeah, thank you, Susan. And can everybody see me? My video is not popping up, but you can. Okay. Yeah, I appreciate the opportunity, and I'm glad to be able to close this out on this part of the conversation. That's a extra special opportunity, I guess. So I'm the energy section manager at the Department of Fish and Wildlife, and the DFW's main interest in the siting of generational or transmission lines is really protecting habitat and the species that rely on that habitat. And my personal role as energy section manager is really to focus on habitat protection around energy facilities. And that includes all kinds of energy facilities. So it's fish passage at dams, at hydroelectric dams. It's lately we've seen a lot of solar proposals throughout this, the last few years, certainly ramping up. So our interest, DFW's interest in that is the same, different species, different habitat, but protecting especially the endangered and threatened species that rely on that habitat. So we sort of look for ways where in siting that can happen. Similarly with wind projects, with pump storage, any of these things, it's kind of the same overarching principle of protecting the habitat and the species. With siting of transmission lines, it's the same. It's granted, it's the challenge is a little bit different, or a lot different, but it's the interest that DFW has in it will be the same concepts. And so basically we're looking to avoid those impacts, any sort of significant impacts to the endangered and threatened species or to the habitats around those. We'd like to avoid them, and where it's appropriate, and it's not always appropriate, but where it is, to mitigate for whatever impacts there are in certain places. DFW often, and in these situations, lacks direct permitting authority. So we tend to rely, like for hydro, we're relying a lot on ecology and working with ecology and sort of through them, through 401 certifications and things. So similarly, or I guess I should say, with that said about the lack of permit authority, we try to influence the process in other ways. And one of those is, or one idea of that is early and frequent communication through work groups like this, which is super helpful, and encouraging or having others encourage applicants for if someone is proposing a project somewhere to get in touch with us. And I know that's the same with Department of Historic Preservation and with tribes. And in terms of wanting to be, I don't want to speak for anybody else, but I think wanting to be involved early and often, and that it allows for a more productive conversation. It allows for more interest to be properly considered, and so DFW wants to be wants to be involved early and often. So this is a great example of that. Seeing if I have anything else, and I don't think I do. So that's it. Yeah, thank you.
That's great. Thank you, Ben, very much. Interesting, really interesting information, and interesting to hear how each of the panelists here come at this from different ways and have different authorities. And so you're working through ecology, Ben, for some of the things you mentioned is insightful and helpful to know. So
Susan, can I just add something here that's kind of important on the Boardman transmission line? One of the things we ran up against was sage grouse versus cultural resources. So the question came down to which alternative do you pick? One alternative had way more impacts to cultural resources, and the other alternative had way more impacts to sage grouse. And it really becomes a difficult issue of having to pick one resource over the other. And that is something to think about as we get in those situations. And where do you go?
Thank you, Allison. That's again, I keep saying, wow, that's really helpful. But that is because those trade-off conversations can be very challenging. And I heard Stephen talk about that at the beginning about don't always trade off cultural resources from his perspective. So yeah, I think all the panelists gave us lots to think about. I took lots of notes. I think we're dropping a couple things on the mural board that we heard as well. So thank you all. Really appreciate the preparation too that you all brought to this. Obviously had thought about what it is you wanted to convey, and we're very glad you're going to be in the room with us for the rest of the conversation. So with that, I'm going to scoot us over to the Cascade Crossing conversation if people are ready for that. We have Tim McMahon, we have Doug Young. Tim is with Stoll Reeves. Doug Young is with the Forest Service, who you met in the, I'm getting the slides up here, who you met in the Boardman to Hemingway conversation. So again, another interesting case study that gives you things to think about, and maybe some things that worked well or some things that you might want to contemplate could be better. So with that, Tim, may I hand this over to you? And unless you want to show the slides, I'm prepared to show those for you.
Good, I appreciate that. Thank you, Susan. And in a minute, I sent a statute this morning to Joe that I'll ask you to pull up in a few minutes, not just yet.
Gotcha.
But let me lay kind of a little bit of background here. First of all, Stoll Reeves Law Firm, it's where I work every day, is spelled R-I-V-E-S, just so you know. And I have, I come to this place of being an energy facility siting lawyer in both the state of Washington and the state of Oregon. I'm very, very active. Really, all I do is energy facility siting. And at the moment, that means entirely wind and solar facilities, utility scale wind and solar facilities. In terms of my history, I was lucky to be the Port Townsend city attorney for about 5.5 years before moving to Oregon. And in those heady days in the early and mid 90s, I was very active as a representative of the Washington Municipal Attorneys Association in the regulatory reform movement in those days, and talking about expediting permitting for just kind of at the county and local level. So a lot of this resonates with me. I haven't given a ton of thought to expediting transmission lines, but it is just really, really fascinating to me to kind of hear this and kind of, get the vibe of this crosswalk to where I used to be as a government lawyer. I'm going to walk through, I'm going to eventually get to Cascade Crossing, but I'm going to walk through some other projects first, because at least the way my brain works is everything's foundational, and I can understand, something if I understand the background and the foundation of it. So I'm going to walk through some other projects that kind of leads us up to Cascade Crossing. So bear with me. This is actually, like, from the get-go, in fact, about Cascade Crossing, even though it might not seem that way from the beginning. I am a huge beneficiary of Sarah's presentation, because I don't have to talk about the FSEC process, because she did it fabulously. So I'm just going to talk about the projects and the precedent and really a lot of the issues that you've all touched on here. And then finally, just an introductory thing. Great to have Doug Young on board. Doug, I know you've probably looked up your lawyer jokes. You said you were going to do that. I tried to find biologist jokes and they aren't funny. So I don't come with any of those, but we'll see how you do when we get there. Doug and I have known each other for a long time. I'd say bumped heads a time or two. And it's really pretty cool to have him here with me today. So with that, if you wouldn't mind just getting to the first slide here. So just again, very introductory here. My first foray into this was early 2000s-ish, when we were contacted by PG&E, who had this big ambitious transmission line from Canada to California, and we spent a few days down in PG&E's offices in California, and we're starting to kind of map this out. And somewhere along the way, they stumbled over some WEC problem or whatever, so that one didn't proceed. But it really got me thinking and got us thinking about what this would look like. So it's just fascinating to me to see this all really start to fire up again. and be really seriously considered, because it is, you know, as we look at the proliferation of renewable energy development throughout the region, it's perfectly obvious to me that that we need to do something about logically connecting these systems together and building the infrastructure to address climate change needs. So again, it's a little back to the future here, and it's great to be a part of this. So why don't you pull up the next slide here? I'm going to start with our experience with Northwest Natural Gas South Mist Pipeline Extension Project that we permitted in Oregon. Application filed in the year 2000 and site certificate issued in 2003. This was a 62-mile, 24-inch natural gas pipeline that cut right down through the fertile Willamette Valley. It was approved and strongly encouraged by the Oregon Public Utilities Commission to deal with their concerns and Northwest Natural's concerns about some fairly significant gaps and service problems within the service territory, and the ability to really keep the furnaces running during cold winter months and the like. So there was a fairly strong imperative endorsed by the OPUC to move this project along at all deliberate speed. However, we ran into, in fact, we knew it was coming, but we ran into a very significant statutory issue that really we in terms of from some opposition from intervening parties, it became very clear to us that there was tantamount to a prohibition of siting pipelines throughout the exclusive farm use zone in Oregon. So we, Northwest Natural, and my firm spent a considerable amount of time for a couple of years in a legislative session to formulate a solution through a very collaborative process to develop a regulatory framework, a statutory framework for permitting linear facilities. So if you wouldn't mind pulling up my statute now, I'm going to kind of quickly talk about this. Sarah lives and breathes this statute. So
right, give me just a second here.
Yeah.
And you'll want to direct me to where on this page, which I'm sure you'll be
There you
prepared to do.
Yeah, actually, that's probably all I need from the statute. So this is ORS 215-275, and in order to enable this project, the legislature approved ORS 215-275, which established a process and a criteria-based series of standards for permitting utility facilities necessary for public service, which is how it's defined here. And most importantly, and I want to focus you on this because it'll be thematic for what I'm going to say, are these A through F criteria or citing factors that are imposed in the state of Oregon on citing linear facilities, whether they're gas pipelines or transmission facilities. And really from these standards, what Northwest Natural looked at and dealt with here in filing the application for the South Mist Pipeline Extension Project was how do we build a case around these 6 factors in a way that meaningfully engages constituents and agencies and answers technical and regulatory questions to enable a project of this complexity, especially down through the Willamette Valley. So if you can go back to the slides now. And what, next slide here. So this project, South Mist Pipeline Extension, just to be clear, was a utility project. It was not a kind of speculative project. It was specifically a utility project to deal with a need that was defined by the Oregon Public Utilities Commission. And the route of the project was from more or less the Portland area down to the Molalla Gate Station. And if you look over kind of on the right-hand side, you see Molalla. So it was a 62-mile pipeline. What Northwest Natural needed to accomplish here was how to identify and evaluate the constraints from north to south along this pipeline with a tremendously varied environmental setting with homes and rivers and highways and interstates to cross, and how to kind of logically do that. So we, with Northwest Natural, really, we pioneered what we called a constraint-based analysis that is based on the factors in ORS 215, 275, and we really embrace the statute and use them. So in effect, individual criteria is necessary in looking at systems operation and connection requirements. And these criteria and the constraints are rarely understood in isolation. A few of them create on their own an absolute necessity to locate a linear facility in a specific location. Others define severely constrained locations where you simply can't, get through a certain area and you have to find kind of a better way around. So both positive and negatively constrained areas based upon favorable locational factors that the statute really guided us toward. So Northwest Natural identified 10 locations and areas where one overwhelming constraint would make a particular location the only reasonable place to locate the pipeline. Several constraints together force a location, and all of that added together in this very complicated process created kind of a locational dependency on how the pipeline needed to be built through this area. So as we were looking through the process, we identified a number of really key factors. One is system tie-in locations for the pipeline. Second, construction-related constraints, geotechnical issues, river, creek, and highway crossings, and isolation valves that by law have to be placed not more than 4 miles apart. And we had 11 isolation valves that had to be placed in logical locations, and then dealing with existing easements and rights of way throughout the whole corridor. So again, an extremely complex process based upon a range of different factors to enable a continuous project where you could kind of link all the pieces together and get from point A to point B and have a project. And it is not an easy thing to do. So, but again, Northwest Natural based that process on very, very clearly defined constraint points and factors that guided the ability of the project to connect all the pieces together and ultimately have a facility that worked. So I'm going to focus on just one of the 11 constraints, just because this, I think, is a pretty interesting example, and that's the Willamette River crossing. So we had to route this pipeline underneath the Willamette River. We had to find a location amidst a whole bunch of residential subdivisions to lay down enough area for a directional bore under the river that was able to, for a 2,400 foot length, get into the river with about a 660 foot crossing from bore point to bore point, required depth of a minimum of 30 feet below the river bottom, and a configuration that the bore would be approximately 3,300 feet with a 15-degree entry and exit angle. The boring operation required a pipe laydown area that was positioned perpendicular to the river on the side with a crossing side that allowed the pipe pole to be pulled from a distance. So this required a considerable amount of land that was relatively flat to get it, underneath the river without disturbing, the river itself. It was the one place that we defined, the Northwest Natural defined, really the one place that we found that had the necessary characteristics to enable that horizontal directional drill in order to build this project. So I highlight that to kind of talk about the complexity of linear facility siting here that's very much in the state of Oregon driven by some pretty clear statutory factors. So take me to the next slide, Susan. We were involved in quite a few projects during these years, and one project that I think really punctuates some of the themes, the expediting themes that we've been talking about, is the Ruby Pipeline project that was sponsored by El Paso Gas and Electric. And this project had a relatively small area of contact with the state of Oregon and Southwest Oregon. Doug Young was actually involved in this one. This project was permitted through FERC at relative light speed. But this project wasn't permitted by skipping a bunch of steps or not, complying with any particular factors or requirements. This project proceeded at light speed because it had been in a very deliberative planning process with agencies for years before the application was filed. And we had many engagements with stakeholders, with tribes, not just in Oregon, but east of Oregon, state, county, and federal agencies, with a very consistent and disciplined approach and focus to consultation, both with tribal organizations and with agencies, driven by what was at that time a very consistent federal policy and a lot of kind of mandates and imperatives at the state level. So Ruby Pipeline filed that application in 2009. On April of 2010, FERC approved the application. Construction began July 2010 and was placed in service on 2011. That was very fast. And it wasn't, and again, the reason that happened at that speed was a very solid team of participants, very extensive consultation with federal agencies, and a very clear policy-driven approach to moving at all deliberate speed to meet construction deadlines and requirements. So not an Oregon FSIC process per se, but one that I think, for me at least, was foundational to kind of figuring out how to do these linear facilities. So if you go to the next slide, Susan. This is the map, Ruby Pipeline, and 680 miles of pipeline, again, permitted at a real clip. And I'll be interested in what Doug has to say about that. The next slide, please. And I'm going to just cruise through these really quickly. The story I would tell here, and again, this just kind of is influential to me and how I've thought about linear facilities. We were working with the Clean Line team on this east to west big idea transmission corridor to bring Midwest renewable energy to the east and to the west, with an interconnecting linkage of transmission lines, sponsored by Clean Line Energy, brainchild of Michael Skelly. Some of you may know Michael or know of Michael's reputation, but that project was conceived at a time when we had an administration that really understood the imperatives of climate change and wanted to empower the construction of renewable energy as rapidly as possible by ensuring that the transmission infrastructure was there to move power into urban areas from the wind energy rich areas in the central part of the country. So next slide here. We were particularly working on the Western Spirit piece of this project that was kind of an interconnection into the Four Corners area of Colorado, Utah, New Mexico, and in that project, the goal was to really anchor, kind of have an anchor tenant project in New Mexico that would facilitate and enable the construction of the transmission line into California. So next slide, please. Actually, let's just go to the next one. So what happened, unfortunately, was a very significant change in policy with the Trump administration, and a pullback from any climate change imperatives. And it really did a number on the commercial imperatives and capabilities of this project to undertake its purpose and need. So so the project ended up kind of selling assets and parceling out the project attributes to different players. The Western Spirit project was sold, as I show here, to Pattern Energy. They built it, and they constructed an 1,100 megawatt generation wind energy facility in New Mexico that was able to move power into California. But the rest of the project really, for the most part, didn't succeed because of a very significant disruption in federal policy. So next slide. And this is the odd configuration of this project. The routing was intended to avoid a number of different constraints and problems. That's why it looks really weird, was to kind of get around some significant issues with metropolitan areas, some difficulties in tribal consultation, some difficulties in dealing with populated locales. But in any event, that part of the project was completed. And I guess kind of thematically here, to me, it demonstrated the need for very, very consistent policy to enable these projects to succeed. And when you have a big wobble in policy like we had with the disruptive nature of the prior administration, the regulatory and commercial need for the project clearly was compromised. All right. With that, let's now get into Cascade Crossing. And again, sorry for all that background, but to me, it's just sort of the logical way of going about this. Okay. Cascade Crossing started at about the same time as Boardman to Hemingway. In fact, I think we were slightly ahead of Boardman to Hemingway. It was originally conceived as a 210-mile, 500 kV double circuit transmission line from Boardman to the Salem area. It was intended to pick up a whole bunch of wind energy generation facilities that were being constructed out in the Columbia Plateau and surrounding areas. The project required the construction of a number of new substations, and ultimately the project was terminated after we filed notice of application, preliminary application in 2013. So we worked on it pretty hard for several years until PG ultimately withdrew the application after submittal of an amended application. So Bonneville and PGE ended up entering into a memorandum of understanding to seek a mutual transmission capacity solution that occurred in tandem with a time when wind energy facility development really slowed and some of the queue requests were removed from some wind facilities that would have benefited from the project. So let's go to the next slide. So this is a map of Cascade Crossing, and so just to talk about the complexity of this. So you see Boardman on the right-hand side, kind of a key stakeholder, probably the most important key stakeholder really was the Confederate Tribes of the Warm Springs down in Seminasho. You see that area just north of Madras. So that's the Warm Springs Reservation. North of that is the Mount Hood National Forest. So the preferred transmission line corridor took the project through the Warm Springs Reservation. PGE negotiated a significant memorandum of understanding with all of the federal agencies potentially involved in the project, and with the Warm Springs Nation as a signed party to the MOU. And it was intended to be, and it was a cooperative agreement to make sure that all parties were at the table, that there was active consultation, that all stakeholders were actively and early involved and constantly involved in the process. So let me see. And so you see here those little wind turbines up in the upper right-hand corner, and that represents a number of requests for interconnection into the transmission line that was a very significant part of its commercial feasibility and reason for it being proposed. And then the final connection down to the urban area is the Bethel substation near Salem that would have allowed additional power to flow into the Portland metropolitan area and areas south. So next slide. Okay, so this shows the 4 substations that would have been constructed along with the transmission line: the Cedar Springs substation on the north, Grassland Station near Boardman, the McCalla substation just west of Morrow, and then finally the proposed Pine Grove substation just north of the boundary of the Warm Springs tribal reservation, and then ultimately connecting to the Bethel substation and the Santiam substation, Bonneville substation further to the west. So the complexity for me doing this was having to reach back into memory land to remember how all this worked. But I was able to pull together a fair amount of information that I'd like to just kind of walk through now, and then hopefully have an opportunity for Doug to jump in and for some questions. So PGE established siting criteria both for the transmission line as well as the substations that reflected those 6 locational requirements in ORS 215-275. Again, following the pattern and the foundation built by Northwest Natural with the South Mist Pipeline extension, really echoing a lot of the siting strategies that Northwest Natural developed in permitting South Mist Pipeline extension. And again, this also, of course, was an FSEC, an Oregon FSEC jurisdictional project. So the substations themselves really defined, those locations really defined a lot of where the transmission line needed to go in order to meet the interconnection needs from the wind generators out in the eastern area of the state. And in developing the siting standards and making sure that we had addressed stakeholder concerns and that we had addressed environmental and natural resource constraints, the siting criteria for substations included considering jurisdictional waters, impacts to streams, rivers, and wetlands, and that shaped where alternatives needed to be considered and available. Existing land use, the opportunity to find sufficient sites in the right location with the right zoning for substations, addressing risks to protected areas. In Oregon, FSEC has a protected area standard that requires some consideration to be made of areas that are listed by law as protected from various different impacts. Historical, cultural, and archaeological resources. PGE was engaged in very deep consultation with both the Warm Springs and the CTUIR Umatilla tribe and other Native peoples in uncovering and dealing with and trying to understand archaeological resources along this entire route, and particularly the substation areas because of the level of disturbance to the actual ground where the substations were proposed. Natural hazards, as with Northwest Natural, with the geotechnical issues for the pipeline, citing this project over the Cascades with a lot of geological and geotechnical hazards and issues was not an easy task. So that was identified as one of the key siting criteria for substations. The site size, we needed to find sites of 20 to 30 acres for substations. Ownership of land, finding sites with relatively few landowners involved, and sites where title to land could be readily ascertained. Access to site, in other words, not needing to build a whole bunch of new roads. Distance from the proposed actual transmission line route so that we had locations as close as possible to the wires themselves. And then transmission line crossings, not wanting to kind of cross over other transmission lines, most particularly Bonneville lines and others. So from that, PGE developed, a series of siting criteria to avoid impacts, and that included avoiding the Columbia Ridge or the Columbia Gorge Natural Scenic Area, avoiding wilderness areas, avoiding to the best extent possible crossing of the Deschutes, John Day, Clackamas, and other wild and scenic rivers, avoiding inventoried roadless areas, avoiding the Umatilla National Wildlife Refuge area, and avoiding state parks, all to the best extent possible. Again, not easy stuff with a linear facility that you can't just kind of break and move at a particular location when you hit something that compromises the ability to build a linear transmission line. So PGE then focused on the transmission line itself and essentially conceived of the transmission line into 5 different segments. And within those segments, PGE assigned dozens and dozens of constraint points and constraint areas. Given that we're running short on time, I'm not going to walk through all those. But in essence, the constraint evaluation process led ultimately to the siting decisions and the ability to find strategies to avoid and minimize impacts to the project to the best extent possible, and to develop a transmission line corridor that to the best extent we were able to meet the commercial needs of the project while also being sensitive to the many competing resource issues and problems. Okay, let me just kind of quickly sum up here, and so that we can get Doug.
Tim, we've got about maybe 5 more minutes. I would really
Okay.
like to give people a chance to ask some questions. So, and I know
Okay.
you need Doug to jump in here too.
Yeah, all right. Yeah, well, just very, very quickly here. These projects are not considered in isolation. We adopted a very fundamentally a land use approach. The question is always how to make a current legal framework sufficient to function in a logical fashion, how to develop projects expeditiously, particularly now that we're really needing to deal with and address climate change issues. And how really, and this is something that I think really bears some discussion, how to do any of this with inconsistent state laws and without the concepts of preemption to enable facilities. So, Doug, I hope I've given you enough time here.
Now, just a few minutes, Doug. Probably not as much time as you wish.
That's all right. I want to start by basically saying I'm sorry I put up a lawyer joke. I couldn't help it. So Tim, thank you for that amazing story of so many different linear energy projects. Ruby Pipeline was probably the most amazing linear project I worked on. I was with U.S. Fish and Wildlife Service and lead for the state of Oregon. I'm sorry, the Oregon State Office, U.S. Fish and Wildlife Service during the Ruby Pipeline, 2 years of intense work and construction. We had to pull together 3 regional offices, 4 state offices, and get alignment with that project. It was an amazing time when Ruby came out. It was the same time that B2H was getting started. It was the same time that Cascade Crossing was getting started. In Oregon, we were experiencing some of the highest numbers of proposed natural gas pipelines through our state, the highest offshore wind proposals anywhere in the country. We moved from number of megawatts built wind projects nationwide from 16th to number 4 in a matter of 2 years. And we had a couple of the new transmission lines proposed in that point, B2H and Cascade Crossing. We had a need to get organized internally as an agency. And so from the field offices to the state office, to the regional office, to the Washington office, it was a unique opportunity in time. In my 30-year plus federal career now, I've never seen a time like it where there were so many convergent pressures on us that we just got organized, and we were functional. We had experienced teams, and we had figured out some tools to help the process work forward. And so I've got some perspectives from my Forest Service job now about Cascade Crossing, but a couple of perspectives that I would also observe. Cascade Crossing brought together a lot of agencies initially, but I gotta say that the folks being assigned by the entities that were gathered together may not have been the right group. And after a year or two of really struggling, in my mind, fair or unfair, Portland General Electric brought in somebody who was their lead negotiator for settlement agreements on hydropower work, knew how to do facilitated pressure group processes, brought in mediator where needed, and brought the right people to the table with the common structure that, as Tim was walking through there, I'll give lawyers some kudos here too, really resulted in a process that seemingly started to work after a couple of years. So it helps when you're deploying these multi-agency, multi-entity teams to have a real a utility, a proposal that is risk-taking, is willing to fund. In our case, Fish and Wildlife Service was able to receive applicant-funded consultants. So we had a firewall so we could manage those teams, but we didn't have to fund them. And we learned to deploy those experts to try to keep in step with the push of the process. That was super useful. I think some of this is similar themes to Boardman to Hemingway. Having senior leads that are experienced, that can be assigned as part of their annual work plan and then held accountable for sitting at the table for long periods of time. That's what these linear projects need. You can't have a 300-mile long transmission line without multiple areas where somebody's resource is getting gored, and you gotta have these specialists that are willing to negotiate. Tim kind of reflected on that siting process. Really early on, we set up a siting process and all agreed upon that siting process. But one of the reasons why that worked is we had this outlet that we agreed to, and the company took the risk around a compensatory mitigation package. So if in the end there were these trade-offs where a resource was going to lose, there was a known compensatory mitigation package available for it. And I think that reassurance moved process forward more successfully in that situation. I know Fish and Wildlife Service worked hard at establishing kind of some programmatic approaches. For instance, the project went through Willamette National Forest in its final iteration, and it went through multiple northern spotted owl circle areas. And we came up with a programmatic approach for quantifying those effects and offsetting them through a compensatory mitigation standpoint, because you couldn't, if you didn't go through the owl center, you were in a proposed wilderness area, or you were crossing a wild and scenic river. So we, even down to some of these very critical for Fish and Wildlife Service and the Land Management Agency resources, we found ways to have an outlet valve to eventually make it work. We were able to, once again, do those briefings regularly up and down our command chain. And that was really important to know that our agency, our administration, had our back on these decisions and these agreement points. What other examples? Maybe.
Hey, Doug, we just have about 3 minutes left before we need to wrap up. I'd love to give people a chance to ask questions. So if you have just one more really critical thing you want to share before I see if anyone has questions, that would be great.
Susan, I think I'm done. Thank you.
Okay. And again, such great information. I'm sorry to be squeezing you guys a bit. Allison, I see your hand is up. I would invite others, especially if we haven't heard from you yet and you have a question, please raise your hand. Go ahead, Allison.
So, Doug, how do you do compensatory mitigation for sacred places or traditional cultural places? I mean, are you speaking of compensatory mitigation like you're giving people money, or regular mitigation?
So in the context of northern spotted owl, as an example that I can speak to, Allison, our idea was, if you have an acre of habitat that you're going to remove, and then indirect effects from the new power line that spread outwards, we had a calculator that said for those direct effects, it was a 7-to-1 ratio or something like that for acquiring and then managing in perpetuity similar type lands. We
Okay,
had
so that's good to understand. So I think the problem we're going to face in cultural resources is you can't do something like that for cultural resources. And that's going to always be a bit of a hurdle, actually a lot of a hurdle, actually a big hurdle.
well, I guess I don't want to act like a lawyer would act in this case.
Oh,
and
please
pretend to
don't.
be an archaeologist or something like that. But if our programmatic agreement off of our historic plan indicated a series of potential ways to treat, which included, how to protect the site and how to compensate additionally, couldn't there be, this is where every entity to actually make one of these things go forward, every entity needs to come to the table with the most creative mechanisms possible. And under the Endangered Species Act, my colleagues were sometimes horrified with some of the creative ways we were coming up with. But it helped us stay to the table, and it gave us, good standing and ultimately a conservation benefit in the end from this never constructed project. And I guess I would challenge all entities that would sit at the table for a new project to try to staff it up and think of it in those kind of really creative, out of the box ways.
Thanks, Doug. And thanks, Allison, for the provocative question there. Are there other questions? We have just another couple of minutes. I know we need to wrap up because we need to be respectful that people plan till noon here. I'm looking to see if there are other hands up. I'm actually not seeing any. And Tim, we just went right from you to Doug to questions. I'm just looking to see, was there anything that Doug said, Tim, that you just wanted to comment on before we wrap this up today?
No, and Doug and I shared this observation last week when we talked about the importance of the team and the people at the table and the intent to be collaborative and to really wrestle hard issues to the ground. I mean, and I, Doug does a great job of that and was really a leader in those efforts during that project and others that we worked on together. So there's no question about that. There's no substitute for that. Another just quick observation about Cascade Crossing that Allison sort of provoked me to think about this. PGE had the advantage of a very long relationship with the Warm Springs Nation. They share ownership of the Pelton Butte Dam, as I recall, and there was a very, very long partnership. So they brought those relationships to the table, which helped a lot in kind of building trust around some of the cultural resource issues that we had in that project. Again, having the right people engaged with the right sensitivities and the right motives for success within everybody's paradigm is just really critical.
It's great. Thank you so much, Tim. And I had a question sent to me, just wondering, I don't know if you and Doug or Doug, and honestly, any of the folks that presented today that are not on the group, if you're able to be on with us tomorrow at all, just for some ideas or Q&A, that would be wonderful. Doug, I'm not sure if you are, or Tim, but if you can jump in at all tomorrow, we would be grateful, of course.
Yeah, Lorna Luby volunteered me for this job, and I am actually interested in participating tomorrow, at least observing tomorrow, because I kind of got the bit in my mouth. So I will be on board.
All right, very good. Well, again, thank you both so much. Really appreciate it. I'm going to go ahead and move us into our wrap up here, and then invite Kathleen to make some closing remarks. So as far as the wrap up that I wanted to share with you is just that we've had a lot of information. We haven't had as much interaction time for the group to ask questions and to have a conversation with each other. We will have more time for that tomorrow. And so I hope you were listening carefully. I'm sure you were, took some good notes. If you have time and can jump onto the mural board before you end your day today, that would be very helpful for the facilitation team. We're going to try to pull stuff together for you to discuss tomorrow. So to the extent that we're able to pull anything together from today, that would be super helpful. Again, a reminder that we have public comment opportunity tomorrow around 11:50 a.m. So we'll be looking forward to that. And that the emerging principles document that's for the things that you were contemplating before today has been sent to you. It's a shared document, has a link. I don't think we have any comments in there yet. I'm going to ask Lauren to resend that out by email, that link to that shared document. Hope you'll have a chance to take a look at it. I think it's 4 or 5 pages. I think that's right. Would really be helpful. And it might help you a little bit to think about the task for tomorrow as well. So I'm going to stop. Kathleen, would love to turn it over to you for any closing remarks.
Thank you, Susan, and thanks everybody. What an incredible morning of conversation, participation. I just want to thank everybody for putting forward your thoughts, your experiences, how we can move forward in this space. These are not easy issues, and we have to really reach out, listening to and learning from everybody. We have different worldviews as we approach this work, and we need to incorporate all of those living experiences, lived experiences as we move forward if we're going to find out our way to work forward and have a green energy future. We need all of these perspectives to be present as we go forward. So thank you so much. And I look forward to our conversation tomorrow.
All right. So we'll see you all at 9 a.m. I believe is our starting time tomorrow. So thank you, and we'll see you then, and hope to see lots of cool things on the mural board tonight.